Supplementary list. Pronouncement of judgment, item number 1.
I'm praying for a different date, Your Lordship.
Thursday means which matter?
This MS Jorapat, Your Lordship. WPC number.
We have to do Thursday.
Please, Lordship. Lordship, I beg to mention item number 8. Your Lordship, I have informed to the other party also, GHATC. This is regarding the Assam Garo Hills land and revenue regarding the challenging that matter.
You seen the judgment in the other case?
No, there is no judgment.
Have you seen the judgment? No. Have you
Still,
seen the
it is
judgment?
reflected in the.
Have you seen the judgment regarding the market regulation?
I have not seen, Lordship.
You have not read?
I am not there because.
Will that case have a bear? Will that judgment have a bearing in this case?
7, item 8. So
I will go through that judgment also as well, Lordship, whether it has some connection. Here, the basic the subject matter is regarding the Garo Hills Land and Revenue, that act which is adopted from the Assam Land and Revenue.
Well, generally, he'll appear in other matter also, correct?
Other matter I appear. In this matter I am not there.
Oh, you're not there? Yes. But
Number 7 I am there.
After
7. You mentioned number 7, correct? No.
number 8, my lord.
But connect with number 7.
yes,
Number-
Your Lordship.
Number 7 is not my.
Number 7 last order was this, that sorry, petitioner wanted to file some additional document.
Where's Mr. Siddiqui?
Your Worship, he cannot come due to personal difficulties.
Then you have to file something.
Yes.
I have no idea, Your Worship.
I can find.
Because 2 dates have gone thereafter. If they have nothing to file, then we can proceed.
Satuka. Mahma.
So download the judgment.
Yes. It's been filed
Yes.
on 28/7. Correct.
Yeah.
The who's assisting Mr. Siddiqui in the matter?
A.J. Moment, Your Worship.
Where's Mr. E.G. Moment? Yes, on the prayer of Mr. P.T. Sangwa. This matter after
2 weeks, Lordship.
after 2 weeks. Yes. Connect this and number 7 also is together next date. Yes.
Apply.
They filed it. Have you got copy? They filed the affidavit. Bring
They
on the
filed.
court. Yes. The patas issued by the district council.
But they haven't given us copy.
Then they collected. You collected.
Mouthful, Lordship.
Lord, I beg to mention item number 9, my lord.
The Fulbari.
My lord, the other matter in the division bench, my lord, it's still pending, my lord.
Okay. After 3 weeks.
3 weeks, Your Lordship. Apply, Your Lordship.
Mr. Bora matter.
Please, Lordship. Lordship, I beg to mention item number 2 from the supplementary list.
Number?
Number 2, Lordship, from the supplementary list.
Yes.
I'm praying for 3 weeks time, Lordship.
No objection, my lord.
Why?
We need some more time, Lordship, to prepare.
Ready for hearing.
Paperwork is ready, correct?
Yes, Your Lordship.
Yes. Item number 10.
Obliged, Lordship.
These all matters are gone. Except for this. Number 1 is called then. Yes. By default. He will.
Daily list item number 1.
I think look at this one. He gives to the mind its own wrong. This is well according to his again. Good. Yes.
Please, Lordship. This appeal is directed against an impugned judgment passed by the learned single judge dated 31st of July 2024. Lordships will recall I am not a party before the learned single judge. Your Lordships have granted me leave to file this instant appeal. The short background is this, that the school in question is a Tilapada Girls SSA LP school. This was established sometime in the year 2000 with the approval of the government. Thereafter, at the very founding year, 2 teachers were appointed. One was Dilwar Hussain, who was appointed to the post of head teacher, and the respondent number 7 herein was appointed to the post of assistant teacher.
Dilwar Hussain.
Dilwar Hussain.
Who's the parent Dilwar Hussain?
He's not a party violence. I'm just giving you Lordships a background of the facts.
Okay.
He resigned from this post, and after a vacancy arose to this post, the managing committee of the school appointed the respondent number 8.
Your parent was number 8?
Yes. Respondent number 8. Respondent number 8 is the original writ petitioner before the learned single judge. It's at this point.
Supriya Khatun.
Supriya Khatun, my lord.
Yes, no, 1 second.
As the array of parties is at page 2 of my writ appeal.
That means that is 1 to 6.
1 to 6 is the state.
Who is representing number 7?
7 is here.
Why is that? Why that
So
side?
7 is also an appellant in item number 2.
Item number 2 is my appeal.
They're also aggrieved with the learned single
The
judge's order.
respondent here in this first one. Okay, Mr. Changrai.
So originally, my lord.
So all the respondents are represented here?
Lordship.
Okay.
They're all represented. So as I was saying, in the founding year, that is 2000, Mr. Dilwar Hussain was appointed as head teacher, and the respondent number 7, my lords, that's Oleda Sheikh, was appointed to the post of assistant teacher. Subsequently, Mr. Dilwar Hussain resigned from this post on account of
Oleda Sheikh in 2000.
2000. So after his resignation, a vacancy arose, and the managing committee, the then managing committee, appointed the respondent number 8 to the post of head teacher.
Yes.
It's also a pertinent fact that at that point, the secretary of the then managing committee was one Mr. Solomon Hussain, who incidentally happened to be the father of Dilwar Hussain as well as the respondent number 8.
So after Dilwar Hussain resigned,
My lord,
the respondent number 8
was appointed to that post of head teacher.
That is Supriya Khatun, right?
My lord,
Was appointed as head teacher.
head teacher.
Okay. Then
My lord, thereafter, this continued, and subsequently, under the secretaryship of the respondent number 8, since she was head teacher, managing committees were constituted and approval was sought from the state government, but the state government repeatedly refused it for several reasons. Ultimately, in view of the absence of a functioning managing committee, the administration of the school stood vested with the state government. And on the basis of some inquiry and some complaints, an impugned order came to be passed, my lord, which was under challenge before the learned single judge. Please have that at page 75. Let's have it. This is an order dated 24th of October 2016. This is passed by the Joint District Mission Coordinator. This reads, as per the inquiry report number so-and-so dated Silsila 15th December 2014, submitted by Shri R.K. Hajong, Block Mission Coordinator, SSA West Garo Hill, Silsila, and as per UDICE 2014, this stands for Unified District Information System for Education, which is filled up for the headmistress itself. It is shown that Srimati Oleda Sheikh is senior to Srimati Supia Khatun. Srimati Oleda Sheikh has joined in the year 2000 and Srimati Supia Khatun in the year 2001. Thus, based on their joining report and appointment letter, Srimati Oleda Sheikh is hereby approved as the headmistress of Tilapada Girls SSA LP School. Therefore, Srimati Supia Khatun is hereby directed to immediately hand over all charges to the approved headmistress, Srimati Oleda Sheikh. So this came to be impugned before the learned single judge in the writ petition by the respondent number 8. My lords, before proceeding further, please also note, my lords, there is no statement here saying that the respondent number 8 is now being downgraded to the post of assistant teacher. Simpliciter, this was a case of appointment of the respondent number 7 to the post of headmister, head teacher.
Head teacher.
Nothing beyond that. Now, assailing this order, the respondent number 8 preferred a writ petition before this honorable court.
Yes.
It will be necessary that I take your lordships to some of the pleadings. Well, the writ petition is at page 44. Please have para 6 at page 48.
Now, was you were not a party there?
I was not a party in the original writ petition because the administration was vested with the state. There was no functioning managing committee at that point.
Okay.
If my lords have page 48, I'll draw your lordship's attention to para 6. Just to understand what was the basis of the writ petition, my lord. This reads that the petitioners state that the post of headmaster of the school had fallen vacant due to the resignation of the headmaster of the school on 15/11/2001.
5/11.
So I apologize. 5/11/2001. The managing committee of the school had advertised the said post-wide advertisement dated 11/11/2001, inviting application from the local candidates to fill up the post of headmaster of the school, and further in the said advertisement was stated that preference will be given to local girl candidate. Well, let's please see the advertisement once. This is at page 59. Well, let's have it. This reads application in a standard form invited from the intending local candidate to fill up the vacant post of head teacher of Tilapada Girls LP School. The candidate having passed HSS-LC examination from any Indian school may apply for the post along with necessary documents supporting candidature on or before 15th November 2001. Local girls candidates will be should be preferred if any candidate should have appeared before the MC to show her capacity of teaching on the same day. Now, there is no material to indicate whether this was ever advertised, whether this received any sort of circulation in the media.
They did. Assessment.
Can you see the signature, my lord? It says 11/11/2001.
So 5/11, this Dilwar Hussain resigned on 11. That means just 6 days after that it was advertised.
And please see the date where they're asking the candidates to appear on the 15th of November. Difference of 4 days.
Yes. Head teacher. Yes.
So, my lords will see the date of the advertisement is 11/11/2001,
Yes.
and they're inviting applications on or before 15th November 2001. Just a 4 days difference.
Yes.
And there is no material, as I was reiterating, to show that this was ever advertised in any newspaper or circulated in any media. Then can you come back to para 48 to go through the pleadings again? Page 48.
Yes.
Para 7, my lord. That the petitioner state that in response to the advertisement, the petitioner had offered her candidature for the post of head teacher, and the petitioner was selected and appointed as the head teacher of the school by the managing committee. White appointment order dated memo number so and so dated 20/11/2001. Accordingly, the petitioner had joined in her service and the appointment of the petitioner was duly approved by the respondent number 5. Now, please take note of this one. She makes a positive statement that her appointment was duly approved.
Yes.
Now, please come back to just see the appointment order, which is at page 60. Page 60, my lord. This reads, in the interest of the school, my lord. Please take note of the language here. In the interest of the school, Srimati Supia Khatun is hereby appointed as head teacher of the school, subject to fixation of pay by the managing committees in due course of time from the date of her joining until further order. The above appointment is purely temporary. So two things, my lord. One, appointment was temporary. There is no material in the writ petition or otherwise to suggest that this ever received any approval from the state government or she was ever confirmed to this particular post.
Yes.
But in her pleadings in para 7, she makes a specific statement that her appointment was duly approved by the respondent number 5, that is the state.
Yes.
Then, if I may draw your lordships back to page 49, we see para 8, that the petitioner states that the petitioner was recruited, appointed by the managing committee as the headmistress of the school after participating in the selection process and in due compliance of the advertisement. The petitioner, upon being selected, has been serving as headmistress of the school uninterruptedly ever since she joined in the year 2001. On the contrary, the respondent number 7 never participated in the selection process, which was duly advertised by advertisement dated so and so. Then please also see her statements at page 52, para 15. That the petitioner states that in a recognized private school, the power with regard to appointment, conduct and disciplinary action like suspension, dismissal, reducing in rank, etc. against its employees lies exclusively with the managing committee of the school. Admittedly, the Tilapara Girls SSA LP school is a recognized private school receiving only lump sum grant and aid from the government. As such, the managing committee is the sole authority to take any action decision against its employees. That the petitioner states that as on date there exists no managing committee in the school, and the private respondent number 7, ever since the expiry of the earlier managing committee, was trying her best to constitute the school managing committee under her secretaryship. However, as per rule in vogue, the same cannot be achieved unless she holds the post of headmistress of the school. Taking advantage of the absence of the managing committee of the school, the respondent number 7 managed to persuade Sri R.K. Hajong Block Mission Coordinator Salsila, who was also holding the post in charge of Joint District Mission Coordinator Dadangiri, West Garo Hills, has successfully obtained the impugned approval order dated 24/10/2016 passed by the new incumbent on the basis of a purported inquiry report dated so and so, as reflected in the impugned order, whereby, now this is important minutes, the petitioner was downgraded from her post of headmistress to assistant teacher, which amounts to reduction in rank, and the same has been done in gross violation of principles of natural justice and without any lawful authority. As I was saying, my lords, the order which was impugned before the learned single judge, there is no mention of any downgrading. Then please also see para 18. That the petitioner states that the impugned order dated so and so was passed by the respondent number 5 solely relying on the joining report of the private respondent number 7, which itself is not a ground for downgrading the petitioner by passing the impugned order. As such, the same is liable to be quashed and set aside. In response to this, the state government filed their affidavit, which is at page 78. And the relevant portion that I'm referring to is starts at page 81. My lord has it?
Yes.
Page 81, para 6, my lord. That in response to the averments made in para 6 and 7 of the writ petition, the answering deponent states that the previous headmaster had resigned since he got a government job. Thereafter, the next senior most teacher for holding the post of headmistress would naturally be Srimati Oleda Sheikh. That's the respondent number 7. However, as far as the advertisement is concerned, the same is not within the knowledge of the department concerned. In this regard, it may be further stated that the headmaster, headmistress cannot be recruited by the said school management committee without any prior permission of the authority concerned, and for any such requirement the constitution of a proper selection board is mandatory, which is absent in the instant case of the petitioner. Hence, the said school managing committee cannot appoint a new headmaster, headmistress by superseding the senior most assistant teacher, that is the respondent number 7, directly, and the same is illegal. Further, if any such advertisement was issued, the same ought to have been issued in some local newspaper at that relevant point of time. The petitioner has not been able to show any such document by which the publication of such advertisement could be established before this honorable court. It is also pertinent to mention herein that the petitioner is the daughter of the then secretary of the managing committee, Shri Solomon Hussain. Therefore, the so-called advertisement as relied upon by the petitioner could very well have been fabricated. That in response to the averments made in para 8 of the writ petition, the answering deponent states that the petitioner has not produced any such documents to show that there was a proper selection carried out prior to the appointment of the petitioner herein. Further, detail as the call letter, the number of candidates who participated in the selection process, merit list, etc. have not been provided by the petitioner other than mere averment. Further, there is no such order of approval of the concerned authority regarding the appointment of the petitioner as the headmistress of the said school. Well, in response to this, the petitioner filed a rejoinder, which is at page 144. Now, it is expected that if her appointment was legal and there was no question with regard to the legality and validity of her appointment, she would produce some material to establish the legality of that. Page 144. This is in response to the state's affidavit. Please have page 145, my lord. Para 4. Well, let's have it.
Yes.
This reads that with regard to the averment made in para 7 of the affidavit in opposition, alleging therein that there was no proper process of selection in appointing the petitioner, the answering deponent denies the same, as the petitioner was appointed on a post duly advertised by the managing committee of the school. Now, by raising the issue at this belated stage, after the lapse of 15 years since her appointment, there has been an element of waiver on the part of the respondent. As such, the respondents are estopped from raising the question as to the petitioner's appointment. Moreover, the same is not an issue for the decision of this honorable court in the instant writ petition, and the state respondents, by raising the issue, trying to divert the attention of this honorable court from the main issue. Now, in my humble submission, my lord, and I'm coming to the impugned order now, the question of her appointment became a very important issue, because unless and until she could establish that her appointment was legal, she had no legally enforceable right. Please have the impugned judgment at page 18.
1-8.
1-8, my lord. But my grievance with this judgment is basically just two observations which are available at page 32. Substantively, what is wrong with the judgment in item number 2, my learned senior will be addressing. If my lords have page 32, there are two observations here which I am aggrieved with.
Yes.
Page 32, para 38.
Yes.
This reads, my lord, again the relevant authorities have failed to note that the petitioner was appointed as head teacher on the basis of an advertisement floated in this regard. Because in my humble submission, there was no material on record to indicate that this advertisement was actually floated, whether it received any form of circulation in the media.
Yes.
Then please see what it says further. There was no challenge to the said selection process at the relevant point of time. Therefore, rightly or wrongly, the petitioner would be deemed to have been regularly appointed as head teacher in the year 2001. This again, my lords, is contrary to the position of law in my humble submission. And then please see further. In this regard, this is important, my lords, because it's understood the court is now going to refer to a judgment which relates to this position of law. In this regard, as referred to by the learned counsel for the petitioner, the case of Hussain Sasan Sahib Kaladgi is found relevant and applicable to the case of the petitioner. Para 2 of the same is hereby reproduced as follows. This reads, before the High Court, it was conceded by the learned government pleader that the appellant was appointed to the post of ADEI as a direct recruit and that he was not a departmental promotee who had been promoted from the post of primary teacher to the post of ADEI. This is abundantly clear from the following passage extracted from the judgment of the High Court. Before us, the learned government pleader considered that the appointment of the plaintiff as ADEI appears to be a direct appointment and not a matter of departmental promotion. He may be ineligible in terms of requisite departmental service as a teacher, but he had the educational qualifications required for the post and he had directly applied for the post, though the application had to come through the proper channel in view of the fact that the plaintiff was in service. In view of this concession, the High Court should have straightaway dismissed the appeal. A direct recruit to a post, it cannot be gainsaid, cannot be reverted to a lower post. It is only a promotee who can be reverted from the promotion post to the lower post from which he was promoted. These propositions are so elementary that the same are incapable of being disputed and have not been disputed. This is the theme of this judgment, my lord. This has nothing to do with the records. This is not a case where he was actually reverted back to the post. And it's very surprising that the order which was passed in 2016, whereby she was removed from the post of head teacher, there's no mention of her being reverted to any other post. She actually went on to continue in the post of assistant teacher. How this happened in the absence of a managing committee is only for the state to explain. Very strange situation. There is no mention of any such order asking her to be appointed to the post of assistant teacher, but she continued, and even till today she's continuing in the post of assistant teacher.
Now who's head teacher?
Alright. The respondent number 7 has been appointed as head teacher
now
by that order of 2016.
No, now that's been
set aside, but from what I understand, the contempt has also been filed.
There is a stay.
Stay by? Is a stay in this case?
In the writ petition.
When subsequent writ petition was filed, there is a state of order passed by the Supreme Court.
Oh, but this Olida Sheikh had filed?
No, my lord. Supriya Khatun has filed another writ petition which is listed before the...
Now she's continuing with head teacher.
Yes,
or head or assistant teacher.
My lord, what happened?
No, we don't know what happened. What are you continuing is now? Are you head teacher or assistant
now
teacher?
She is the senior most teacher, not as a head teacher. No.
She. What is the substantive post she is occupying at the time when this judgment was passed?
She was occupying. She was not occupying as a head teacher. She was occupying as a senior most teacher of the school, lordship.
So assistant teacher. There are only 2 posts.
My lord will kindly appreciate when I move the first petition, my lord. Then
you already had. You only
that impugned order was state, lordship. Impugned order was state. Then I filed that there is a violation on the part of the state respondent. Despite there is an order of the state, then they have revoked that order, that impugned order, for that since the matter was pending before this honorable court. Then subsequently, lordship, they have issued one order saying that the earlier order giving effect to the interim order is hereby revoked, and the appellant of the second petition was given the power to act as a senior most teacher in the school, not as a head mistress, lordship. That the stay order was operating, lordship, in my favor.
So you mean to say respondent number 7 is functions as senior most teacher till now?
Till now.
Okay, very good. Yes, please continue.
If that was the case, then he would not have argued before the court that there's been a reversion or there's been a downgrading. It was his case before the learned single judge that there has been a downgrading. Downgrading to which post? To the post of assistant teacher. Now they are engaging in semantics by saying it's not assistant teacher, it's senior most teacher, not this teacher, and so on. So we have to go by the records, my lord. His entire pleadings before the learned single judge in the writ petition was that now I have been downgraded to the post of assistant teacher. And these are the judgments that he placed before the learned single judge. So I'm concerned with these observations that have been made in para 38. Both these observations, the first one with regard to the fact that there was an advertisement floated, my lord. This is not supported by the records.
Yeah.
Neither the petitioner nor the state or anybody else has brought on record any documents to show that there's been a proper selection process. Number 2, to hold that rightly or wrongly, because there was no challenge to her appointment for some passage of time, it amounts to a deemed regularization of her appointment. This, my lord, is not consistent with the legal position today. And thirdly, my lords will see that the judgment that was referred to by the learned single judge has no nexus with the subject that was discussed in para 38. Now, my lord, the problem with this observation that they are binding on us we would like to proceed against the respondent number 8, at least to examine whether her appointment was legal or not. But by virtue of this binding observation, our hands are tied. So we're only assailing this judgment to the extent that these observations be expunged or at least set aside. Because I'm referring to 3 authorities on the subject.
Is it final hearing or admission hearing today?
It's for admission hearing. But maybe disposed of, my lord, because I don't think there is any difficulty. I'll leave it to your lordship.
After that, it can be.
You're ready with the matter today?
Lordship, since after that my learnership.
No, are you ready with the matter today or not for final disposal?
My lord, can be posted for final hearing, lordship, because it will take time, lordship.
Can be posted for final hearing.
Final hearing, lordship. Yes, this is the admission.
I'll give a short date.
Yes, lordship.
Yes.
1 week.
Mr. Chareso, your appeal also will stand admitted because he has heard Mr. S.N. Leonard, counsel for the appellant. Stop on hearing Leonard counsel. That's fine. And on the concession given by the counsel for the state respondents and counsel for the respondent and other counsel for respondents, the appeal is admitted for consideration. Any other nothing else we exchange, correct?
Not.
Yes. Is under consideration. This the matter we listed on next Thursday, lordship.
Next Thursday, lordship. Can it be after Tuesday? After
yes, Tuesday, next Tuesday. Not next Tuesday. It'll come. Now is the we are on the 19th.
What is 19th?
26th is a Tuesday after that.
Yes, lordship.
Then next Tuesday is when?
5.
Then we'll have it on 28th.
Lordship.
Or we'll take it to 2nd. This on 2nd then. Let's do 2nd for hearing the fixed matter.
I'll leave it.
Along with other connected appeal.
Must.
Item number 3.
Open and shut case. Delay
My lord, I'm filing objection in. Oh, I'm sorry. I'm filing objection in the course of the day in this.
What is this?
There is an application seeking leave to appeal, my lord.
Oh yes. Okay.
So I got a signature, my lord. I'm just getting authorized and filing in the course of the day.
Mr. You've been pleased for, and it's allowed. Oh, this is submits that objections will be filed.
Yes,
in the course of the day. Only some matter after.
After a week.
After 1 week, yes, for further orders.
Obliged.
6.
Any mention?
Please, Your Lordship. Lordship, I beg to mention item number 17.
1 second. Yes.
Lordship, I pray for 2 weeks' time.
A little louder, I can't hear you.
Item number 17, Your Lordship.
Yes, what do you want, item 17?
I pray for 2 weeks' time, Your Lordship.
No objection, Lordship.
No objection. Very good. Yes, okay, 2 weeks. Yes.
Much objection.
May I please, Lordship? Lordship, I beg to mention item number 32, my lord. We are required to file
Dr. Mozika.
We are required to file a rejoinder, my lord, to the additional affidavit, my lord, filed by the respondent.
How many times have you
No, my
taken?
lord, we are filing it course of the day, my lord. So I'm praying if this matter can be taken up next week, my lord.
Yes, after 1 week, MS Adata submits that the rejoinder to the additional affidavit is being filed in the course of the day.
My lord.
She prays that matter be adjourned for 1 week.
God bless
Pray
you.
aloud, yes. Yes.
Lordship, I would like to mention item number 20, Lordship.
20.
Yes, Lordship.
Yes.
I pray 2 weeks' time.
Objection, Lordship. Lordship, these are connected matters.
No, my lord. Actually, my lord, item number 19 to
19 to 29.
27 is a connected matter.
You're with Mr. Nath?
No.
What is the matter about?
It is a service matter, madam.
Service matter?
Yes, Lordship.
Which department?
Medical department. Medical department.
Are they in service or are they out of service?
Actually, this is non-regularization of service, Lordship.
19 to
27.
Yes, Mr. Karwana.
29, Lordship. Objection.
Okay, yes, next week.
Lordship, in the items number 20 to 24, 23, Lordship, they have sought for rejoinder on the previous day.
File it, Lordship.
We'll adjourn it. It's a matter of 2 weeks. Yes, rejoinders, any rejoinders will be filed in the meanwhile, yes. Up to 29.
Lordship.
Lordship.
Lordship, Lodge.
Yes.
May I please, Lodge?
Yes.
Lordship, I beg to mention item number 33, Lodge.
33. Yes.
No objection.
Item number 31.
It's connected?
No, it's different.
33?
33, man.
2 weeks, okay, yes. 31?
Much obliged.
31 after 2 weeks, my lord.
Your Lordship, appearing for item 31.
Yeah, objection.
Respondent number 2. No, Your Lordship.
After?
2 weeks, my lord.
Yes.
Much obliged, Your Lordship. Supplementary list item number 1.
Alu profile. Literal ya. Gamday. Gamday sih. 15 bukan ya? Hearing dia sekarang? Hearing bullet point. 15 guys. Kan orang Sharma forward. Yes. Sorry. What is this?
My lord, this is a Section 11 application for appointment of arbitrator. Fairly simple background behind filing of this application, my lord. Petitioner is the contractor.
When did you finish your executed the work?
It's executed. It's finished, my lord. And we've invoked the arbitration clause. That was.
When was that?
Page 314, my lord. 11th November 2024.
1 second.
Page 314. That is 11th November 2024, my lord. Subsequent to that, matter has just been hanging. Claims are yet to be satisfied. Having no other option, my lord, this application has been filed.
This is 11th December, November 24.
My lord.
Yes, Dr. Mosia, I take instruction.
My lord, I'll file after.
That Mr. L. Gentle and counsel for the petitioner should notice Dr. Mozika is present accept notice on behalf of both the respondents. No further notice necessary. This up to 2 weeks for instructions affidavit. Why you've proposed?
My lord, in fact,
you an arbitrator.
My lord, in fact, there is a panel. We've proposed our names from the panel. If Lordship allows,
they have a panel.
They have a panel, my lord. If Lordship allows, this is the proposal from our side. Maybe learner DSJ can. Maybe learner DSJ can take.
So popular. I don't know why.
So popular.
He's competent. That's what I understand, my lord. So maybe instructions can be sought on this proposal.
Many definitions of competence.
Yes.
But I'll have instructions. We'll propose our own names.
Yes, let him. We won't record this.
Obliged.
We record next date. This.
Item number 2.
Obliged.
Rab Mathur.
What is this? He had moved a mention memo for some relief in this matter. Your Lordships will recall, originally had filed a writ petition before this Honourable Court, which was moved sometime in the month of March. In the month of March, Lordships were hearing this matter on that whole issue of release of the bank guarantees, which I had submitted on account of performance guarantee. So it was our case that the work had substantially been complete. We had already handed over the work. There was substantial materials on record to establish that the state had already taken over the project and they had held several functions in that project. So Lordship's view, I was taking Lordships to the relevant provisions of the contract. And on the very day, the learned AG had appeared, and to oppose my prayer for interim relief, he had placed reliance on a particular document. If your Lordships have my miscase.
181.
My lord, 181.
Yeah.
Yes, please see page 12.
Where's RP General?
Mr. Pandey is there on screen.
I said, where's RP General?
He's in Delhi.
He's in the other room?
He's on his legs.
Yes. So, my lord, this is a matter of some concern because on that very day, I perhaps this is on instructions, the learned AG had appeared and he had produced this particular document before this court, my lords. This is also enclosed along with their affidavit in opposition. I filed a rejoinder disputing this document. Please see this document, my lord. It reads minutes of the meeting in connection with compliance to court order. And the background is this, that last year I had filed a prior writ petition, which your Lordships were pleased to dispose, directing the state to dispose of my representation. I had filed a representation listing out certain issues and they were to address my application within 4 weeks. They did not do this. Now this is the context in which this meeting was held. Minutes of the meeting in connection with compliance to court order regarding Lariti Performing Center held on 13/8/2024 in the office chamber of the Principal Secretary to the Government of Meghalaya Arts and Culture Department. Members present, Annexure 1. This Annexure 1, which is a list of attendees, is not enclosed along with their affidavit for good reason, because this never happened. I was never present. I was taken aback on, I was not present in this meeting, and please see this Annexure 1 has never been enclosed along with their affidavit as well.
Have you mentioned that in the rejoinder?
Yes, I have.
Where's the matter situated right now? For hearing?
So right now what's happened is
in the main,
it's for hearing, my lords. They have raised the question of maintainability. The matter comes up on the 2nd of September. Now in the meantime, in order to frustrate my writ petition, they have taken certain steps. I'll just give you a Lordship's very quick background in 2 minutes. So on the day when I had moved this matter on the 25th of March, my interim application was sought to be resisted on the basis of this particular document. We just go further to read this.
Non-working of lift, what's this?
So these are the, apparently these are the defects in the works, and these have not been cured by the petitioner. So this reason the meeting was chaired by the Principal Secretary of the Government of Meghalaya Arts and Culture Department, so-and-so, who welcomed all the members. After a brief deliberation, the following points were raised and highlighted by HSCL and Directorate of Arts and Culture. Several issues were raised.
It is you.
No, yes, my lord. I'm NCC and HSCL.
Several issues were raised by PMC.
This is the project management coordinator.
And with NCC pertaining to?
I'm NCC, my lord.
Yes.
So
damage,
it says,
okay.
Yes, pertaining to incomplete damage components. And it says,
and then how did this request come then if you're not there?
I was not present.
The
That's the thing, my lord.
Then?
I'm shocked. I filed my rejoinder. I've said this. This never happened. I was never present. Now, interestingly,
you will see it as a totally fabricated document.
Absolutely fabricated. I was not present at this meeting. I was not even in Shillong. Now, please see what happens thereafter. Now, I filed my rejoinder on the 4th of July 25. And I refute this particular document. And I say this is manufactured, and also, most importantly, where is this annexure 1, the list of attendees? So in response, what they do to arm twist me, they issue the second document as page 14. This is what I'm aggrieved with immediately, my lord.
Yes.
Minutes of the meeting for Lariti Performing Center, Maukasiang, held on 22nd July 2025, very recently, at 1 p.m. in the office chamber of so-and-so. Members present, so-and-so. Again, I'm not present here. The Director of Arts and Culture welcomed all present at the meeting to discuss on the matters relating to Lariti Performing Center, Maukasiang, and there's some discussion held here. There's just two things I just point out. There was this whole concern about whether the defect liability period had started. My case was that substantially the work is over, you've already taken over the project. So therefore, this whole period of 12 months, which is the DLP, has already commenced.
You mean has been formally handed over?
Not formally. Then they have to give a letter saying that we are taking over.
The defect liability period will commence from when? From the date of formal handing over, or from the date they start using?
From the handing over, my lord. That is my understanding based on the different stipulations of the contract.
Interpretation.
I'll take your lordships to that. I'll take your lordships. Please see this, the bottom of the page, number 4, non-compliance of rectification. Now, in several other orders, it has been recorded on the submissions made by the Learned Advocate General, the DLP is pending, which means, therefore, presupposes that DLP has already started. It can't be pending or incomplete if it's not started. But please see this. This reads, NCC was instructed by letter dated so-and-so, dated 2/7/24 to rectify non-functioning of water pump, and was reminded that DLP, please note this, my lord, DLP and project handing over remain incomplete. I'm concerned with DLP. If the DLP never started, how was it incomplete? So my question is, when did the DLP start?
No, I mean this. You have to because you see the thing is like this. Any project that is commissioned. Now you're the owner of the project, correct? You appoint, suppose Dr. Muzika as the project coordinator and Mr. Shulai as the contractor.
Lordship.
Okay. In most cases, what happens is that the project is they have done the construction.
Lordship.
Now, due to certain exigencies, you use portions of the constructed building.
My lord.
But then there has to be a certificate of handing over and taking over.
Correct.
That means totally you have removed yourself from the project site.
Lordship.
Because there are instances where,
my lord,
suppose a project is ready, and then the contractor, he says, okay, I've finished my work, he moves out. And we've had cases where there's been vandalism, in these buildings and all.
Same case here, same instance here as well.
See, what has happened is that the contractor has not formally handed over the building.
Lordship.
Even though he might give part of it, so security aspect, it falls on the contractor because until he hands it over.
My lord.
So we had instances like that. So I'm just trying to understand whether it is such a case where there's been no formal handing or taking over. That means totally, once you formally hand it over, that means you remove yourself from the site, lock, stock and barrel.
Lordship, I will satisfy there's a formal handing over. They are disputing this.
No,
they are saying we've not given you a certificate.
In the sense that it has to be signed and delivered.
Yes, I have that.
Then if you have the defect liability period, that will commence from that
actual handing over.
Right.
My lord.
And so if they have any issues within a certain period of the project being handed over, they'll raise it then, and it's onus upon you to rectify those defects.
Yes, correct.
Right, that is how things work.
That's the issue, my lord.
Yes.
So it was disputed by the state that the DLP has not started. There was some issue. At first they said DLP has already started.
Handing over complete.
I'll come to that. Just for a moment, I'll just take your lordship two particular
In this case, what do you want in this case?
Well, in the miscase, they should not take any courses, because here what they're saying is that because I have not complied with the request,
then you file a reply, Mr. Pandey. We like
some protection, otherwise they'll encash my bank guarantee.
Where is that order?
Well, this order of 22nd, it's just pointed here. Please see page 16. But this is not very legible. Please see page 18 is the typed copy.
Yeah.
As mentioned. Action to be taken and discussed at page 19, my lord.
Yes.
Please see number 3. The said performance bank guarantee amounting to 2.5 crores to be liquidated and cash in order to fulfill the present requirements of repairing the defects and problems faced at Larity Performance Center. For the timing, my lords. It's coming up on the 2nd.
We'll dispose of the matter.
Now, by way of this miscellaneous application, what the petitioner is saying that as far as the encashment is concerned, the full background of encashment is concerned, the encashment as such is not bad, but
it's absolutely bad.
Because he was not present in one of the meetings and there was a certain memorandum of meeting which was passed, and a decision was taken in that if you do not comply by curing the defects, thereafter consequential action would be taken. So his grievance is that one of the documents which have been supplied to the counter affidavit, he contends it to be a document which is manufactured. Now the case is that if your lordship sees this document which is annexed at page 12 of the miscellaneous application, which is intended to be manufactured, and if your lordship sees point number 2 for a moment, because it is absolutely clear whether it is manufactured or not. It says issues raised here are highlighted as non-working of lift, submersible pump, reservoir, non-working of electrical poles, and kindly mark this line seated inside the building. And thereafter, point number 6. In NCC, which is petitioner instructed to submit in writing response to the current issues existing with the Larity building for rectification, failing to do so, contractual steps may be opted by the EMC after obtaining approval.
Okay, we're not going there right now.
Friend misunderstands, but I'm saying this. All of this is manufactured.
Yes, fine. But
I am just saying,
whatever it is, Mr. Pandey, we'll keep things as they are as on today. We'll hear the matter on 2nd September. You want to file objection to this? You can before the 2nd. That's it. Yes, heard Mr. SN. Miss case number 181 of 2025. Yes. In WC number 93. You are? Handicapped?
No, I am handicapped to make
any submission.
That no action has been taken in terms of this memorandum. So because this matter is on mentioning, I am not even having the instruction whether any action has followed.
No, to the best of my knowledge, the bank has not received any note, which is why we promptly came before the court.
We'll have it tomorrow.
Yes, they have it tomorrow.
Yes, heard Mr. SN, Miss case 181. Was filed instant miss application seeking stay on the encashment of the petitioner's performance bank guarantee amounting to rupees 7 crores 56 lakhs 60,200. So stop. It's first submitted that the main matter is to come up for hearing on 2nd September. Stop. Mr. S. Pandey submits praise the email to obtain instructions. And this is a matter tomorrow. Yes.
Item number 3.
Because in the meantime, they should not take any steps because we have the entire day today and tomorrow. They might take some steps just for the time being. So even till tomorrow, I'm praying for some sort of
that. No coercive steps will be taken till tomorrow.
Lordship
by the respondents against the petitioners.
Obligement, highly obliged.
Yes.
Maybe the Lordship. Malad, a tender was floated again. This is the second time, Malad. I am approaching this court
for the same
different tender, Malad, of the same nature. This time also, my lord, your lordship will find the tender at page 18, Annex 2, my lord. This is regarding for hiring of civil hire transport for the Assam Rifle, my lord. So, my lord, the route your lordship will find at page number 19, clause number 5.
From Batan Quarters, Sarachip
to Silsa via Sailing and Aizol and back distance so and so. And the approximate contract value is at 7, my lord, 73 lakhs 85,000, my lord.
Yes.
So, my lord, I participated in that tender process, my lord, and they have opened the technical bid. Your lordship will find at page 39, my lord. Type copy is at page 39. Page 39. Type copy is at page 39A. Serial number 1. I am ACC Logistic.
Yes.
I have been disqualified.
Why?
The reason is at the next page, page 40 and page 40A. The bidder had submitted vehicle under of Assam Union instead of Mizoram Union and owes 07X vehicles bus registered with Tripura, but authority route permits not submitted. Hence, the bidder is declared technically invalid. This is a this clause do not contain in the NIT. So, after disqualifying me, I filed a representation online by Gen portal, on the next page.
NIT dated when?
NIT is dated 9 June 2025. But you will find it at page 18, okay. Top, my lord.
Yes.
I can say. So, I filed a representation, my lord. Since there is a clause in the earlier, while opening the technical bid, if your lordship see that page 39 again, my lord, note technical evaluation status may change since representation window is still active. Down below, my lord, it's written note. So, yes. As per this clause, I filed a representation. That is, your lordship will find at page 41.
Yes.
But I said that as this is an interstate movement between Assam and Mizoram, we will send an empty bus from Assam to Mizoram to start our duty. So, it's a request to consider our bid.
As an interstate movement with Assam with an empty bus. Yes.
So, meaning is, my lord, if we take passenger, then only the question of permit is arises, my lord. If we push the bus, empty bus, there is not requirement of my lord, permit. So, my lord, without considering my representation, which I filed on my lord 6/8, on the next date of opening of the technical bid, they have, my lord, opened the financial bid, my lord, now. Lordship will see at page 42, Annex 6.
Yes.
My lord, the bid was 73 lakhs around, my lord, 74 lakhs. So, my lord, private assessment number 5 and 6 herein, my lord, they have been declared as L1. Both are same, L1 and L2.
No, this Sanjay Kumar Singh L1.
Yes. And lordship, if your lordship see my rate at page 7, my lord, page 7 of our petition, my lord, since the tender is of 73 lakhs, my rate was, my lord, 69 lakhs 64,000. Below them, my lord, they have intentionally, my lord, outs me, my lord, from the technical bid, my lord, in order to favor this respondent number 5. And in the same next, my lord, earlier case which I filed earlier, my lord.
What happened in the earlier case?
That is tomorrow, my lord. They filed a reason there. In that case, my lord, this private respondent has been awarded the contract.
Same one?
Same one, my lord. And in the next case, my lord, serial number 4. In this next case, my lord, this is serial number 3. Serial number 4 also, my lord, same, my lord, respondent, my lord. They have been awarded the contract, my lord. So, lordship, we have find a latest judgment of the Honorable Supreme Court, online, my lord, of 2024. It says that, my lord, at any time, my lord, it can be caused, my lord. So,
now has the contract commenced?
Well, the financial bids have been opened.
Has been awarded. Has this respondent been? If that has not been awarded, then you get the subsidy.
But I'll just take few minutes, my lord, to respond. My lord, kindly come to page 20, my lord. This is the essential clause in the tender, my lord.
Yes.
Clause 7.
Yes.
Page 30, page 21. It's a details of vehicle registered on firm's name to the tune of the number of vehicles required in the contract duly countersigned by regional transport officer, district transport officer, along with copy of registration papers of vehicles or an undertaking obtained from concerned state for which tenders are being called, and registered transport association or union duly quoting that the tender is reliable and capable of shouldering the responsibilities of delivering the stores commodities to specified destination, and that the union or association will provide the required number of vehicles. Now this undertaking is required. You lots of recollect in the earlier petition, they produced a certificate from Digboy Bus Association, my lord, bus union. Now this is a route from Mizoram to Mizoram, my lord. You lots of kindly see.
Yes.
At page 19, my lord. Searchship is in Mizoram, my lord, and Aizawl and back. So the entire route is within Mizoram, except for some portion in Silchar. Now they are saying that they will send an empty bus from Digboy.
From Digboy?
My lord. To Searchship, but that's an impractical, impossible proposition, my lord.
Oh, initially,
my lord, for getting the route, my lord, permit, that is not a difficult task, my lord. It can be obtained any time, my lord.
Let us try to understand. Now you say, okay, you have these 7 buses, correct?
My lord.
So if we awarded a contract, these 7 buses you'll bring from Assam, post them as a Searchship, and that'll be used for these trips.
My lord, what he is saying, my lord, every time he'll send one empty bus from Digboy to...
Initially, my lord, then I will take the permit, my lord. This is not a difficult task.
Initially, you'll send a bus every time from...
But it's our cost, my lord. I will pay, my lord.
The thing is that, so you have an empty bus in Digboy.
My lord.
So you send that bus to Searchship.
But for the first time, my lord.
Post it there only for the first trip.
For the first trip.
How can we allow that?
And not only that,
yes,
my lord.
The contract contemplates the document that you are a transporter, you have these vehicles in your custody under valid registration, undertaking given by the registered authority and by the union, stationed in Mizoram only.
Yes,
that is the whole case.
You can do that also, my lord. That is not a difficult task. That cannot be rectified. It can be rectified anytime, my lord.
That is one aspect, my lord. And second aspect, we will also recollect in the earlier petition. The certificate, even from Digboy, is a false certificate, my lord. And the process for blacklisting them,
my lord, for using in every cases. That cannot be a sword, my lord, to cut, my lord, in every cases.
See, Mr. Das,
my lord,
the thing is that this contract is for transportation of these soldiers, armed personnel, right? And it's in the interest of security.
Yes.
Now we can't have it being, we can't issue terms because in case that gets dislocated or it for other security reasons it gets affected. The thing is that transporter, one, should be reliable. Number 2, also the grounds that there is setting up now might not be then a tender condition, but then that
it's not a tender condition. That's the main thing, my lord. Whether it's a tender condition or not, no.
So there's no. So you can bring a bus from Bombay also.
No, my lord. No, my lord. Not like that, my lord. It's an interstate, my lord. It's joint state, my lord. And getting a permit is not a difficult task, my lord. Anytime I can obtain it, my lord. If I
then why did you obtain a permit before you tendered your bid?
Yeah, my lord. Why not, my lord?
No, why didn't you obtain the permit?
But that was not required, my lord. If your lordship see that clause which my senior is showing, my lord, that is written as concerned state, not states.
It's that they have looked at the efficacy also of the entire project. They can't be frustrated. You execute a contract that will be liable to frustration. If you say, I'll bring an empty bus to ferry those.
For the first time, my lord. For the first time, it's nearby, my lord. How can they violate their own tender conditions?
Nearby from Digboy to Searchship.
Yes, my lord. For the first time, in the meantime,
you have to come through.
My lord, I am already working with the Assam Rifle for last 10 years, my lord. These questions was never arised, my lord, before.
Where have you been moving Assam Rifles? Have you said that way in the writ petition?
In earlier, not here, my lord. We have said in the earlier one, my lord. Even we have enclosed a certificate issued by them, my lord.
Have you? Yes, no. But where's the Very difficult.
And not only that, my lord, the submission made, my lord, the same private respondent is given contract, even that is incorrect, my lord. My lord, in the previous writ petition, which is pending, my lord, your lordship kindly comes to page 39A, my lord.
Yes.
On the earlier one, serial number 3, Island Lalu is the awardee, my lord. Here, Island Lalu is disqualified, my lord. So incorrect statement is made. My lord.
Oh, yes, I remember, yes.
Island Lalu is disqualified in this tender, and there Island Lalu is the qualified L1, madam.
They are from the same board,
this submission itself.
They are from the same board, madam. Only to ask me, madam, they have created these things, madam. And my colleague see my rate, madam. And they have opened a financial bid in a Hassas, madam.
They have the right to even reject L1. Doesn't mean if you lose rate also.
But ultimately, it's a public money, my lord.
Mr. Das, you will this matter tomorrow together with other matter.
Well,
we'll issue notice. Heard Mr. We will obtain instructions by tomorrow. Yes. Heard Mr. SP Das. So issue notice. Yes.
Not tomorrow. Day after tomorrow.
Friday.
No.
Day after tomorrow, this court won't be there. Anyway, heard Mr. SP Das. Learned counsel for the petitioner issue notice. Dr. M. Mozika is present, accept notice with DSGI with so-and-so. On behalf of all the Article 124, no further notice required. Only one thing, has it been settled at 5 or 6 or not? That's the only thing you need to know. What instruction do you have?
I'll place that on Friday.
Yes, yes, as a similar matter is coming on Friday, list this matter on Friday.
That's actually coming on tomorrow, madam. So it can all the matters can be listed on Friday.
It is on Friday.
Including my WPC number?
Yes, including
292 of 2025.
Including
292.
Together with 292.
Some protection, my lord.
We will see that till Friday. Roughly 2 days.
Not to issue. Till then, madam. Till then. At least for
no cases
2 days, madam. 2 days, madam.
But no cases.
2 days that will happen, madam. To them, madam. I am working for them, madam. For last 10 years. That your lordship will consider, madam.
He is liable to be blacklisted, madam.
Only after
Friday.
Till Friday. Not do anything.
No interim order, kindly.
No interim order. It's a matter of security. We can't. Without being satisfied, Mr. Das, very difficult. Only the very fact that he bring a butt from Dick Boy to search it.
For the past time, if required, my lord, so. If required, so, my lord. We can obtain it anytime, my lord.
Then to come back to Aizol.
We can obtain it anytime, my lord. Getting a permit is not a
soldiers shouldn't end up walking this way.
No, my lord. But we will not allow them to walk, my lord.
Yes. Friday.
Till Friday, my lord.
No, Friday.
Okay. CL number 4 is also same, madam.
Yes, 4 same order. Where's the petitioner? Who's the petitioner?
Lordship, some MD Marak, Lordship.
MD Marak? Santaman Maunai.
Lordship, the counsel is MD Marak.
LCM.
LCM.
Not MD Marak. Not appear for the petitioner. List on this tomorrow's.
Apply, Lordship. Daily list, item number 1.
This matter only listed. So it will come 28 years.
28.
Obliged. As the matters appeared wrongly today, this on the fixed date, that is 28/8.
2.
Please, your lordship.
Filing of the bullet points.
Bullet points.
We will be filing the
2 days time, your lordship.
during the course of the day.
For 2 days time, your lordship. Filing.
You going to start preparing them today?
Lordship is in the process, lordship.
Yes?
Already prepared, lordship. With some correction, lordship.
Okay. That's what the 1 week is. On the prayer of Mr. Snaitang, this is 1 week for 5 bullet points. Ms. S. Pandey submits that the same be filed in the course of the day.
3.
Please, Lordship. As for the track consignment from the internet, only the respondent numbers 5 and 7 have received, 6 and 4.
I'm hearing on behalf of the responding number 5, 6, and 7.
What about 4?
And 4, you are appearing 4? No. Only 4 is left now. Now 5 received, 7, and then.
He is appearing 5, 6, and 7. He is standing before you.
Now 4 and 6.
He is appearing for 5, 6, and 7.
No. Only 4 respondent 4.
Very good, yes. Only 4. Yes, Mr. Pasante has appeared. We have, as an appeal, we have respondents number 5, 6, and 7 today. Mr. P.T. Sama praise we allowed to obtain serious service with respect to respondent number 4. Yes,
after 2 weeks.
2 weeks. You have one file objection. Yes, Mr. Pasante also praise we are allowed to file objection. Praise allowed this for 2 weeks.
Much less, Lordship.
Item number 4.
My Lord, we have received the affidavit filed by them. My Lord, I am not well. I am currently undergoing treatment at Delhi. So I have a medical history. It's also attached to the writs. My Lord, I'll require 4 weeks to file the affidavit. To file a rejoinder.
What those 2 people who were arrested wrongly?
My Lord.
Mr. Nkara praise has allowed 4 weeks time to file the rejoinder. Yes.
7 also same, Lord.
My Lord, let 7 come up. I have some other submission in it, my Lord. My Lord, I'm requesting the... let it come up, my Lord. 7.
Yes.
5.
Please, Your Lordship.
Yes.
You have filed the affidavit, Your Lordship.
I'll file rejoinder during the course of the day, Your Lordship.
When you want for hearing then?
It's after it.
After 2 weeks, Your Lordship.
Yes.
Fix a date.
MS, sir. Mr. E. Ahmed.
Yes, Islam. Yes, Islam.
Oh, sorry. Mr. S. Islam submits that the rejoinder file close the day accordingly. Just for hearing after 2 weeks.
Pleasure.
6.
May please, Lordship. I'm praying for some more time to file my rejoinder, Lordship. This is recently the private respondent.
You only prayed last time. How many times you prayed?
This will be the second time, Lordship. I think, if I'm not mistaken.
Yes. 2 weeks for them has prayed allowed for rejoinder. This concern.
7.
Much less, Lordship.
Yes, what submission you want to make?
My Lord, here also I have received their... My Lord, I'll be filing a rejoinder. My Lord, here the stand taken by them and the allegations put forth by me, they are varying, my Lord. My Lord, there is a policy that all the police stations needs to be covered with a CCTV camera. And the footage...
Then you put on the rejoinder.
My Lord, I'll file a miscase for that. To preserve it, we don't need it. It may be preserved by them and kept it.
Mr. Nkara pays allowed 2 weeks time to file the rejoinder. Praise allowed. He also further prays him allowed to be allowed to file a miscellaneous application seeking
for preservation of the CCTV footage of concerned period.
Coverage of the concerned police station. Yes, praise allowed. Yes, after 2 weeks.
Obliged. I'll oblige, my Lord.
8.
My Lord, kindly allow me for the 2 weeks to file my rejoinder. I've received on the last date, my Lord.
Yes,
obliged.
After 2 weeks, just pray allowed for rejoinder.
Obliged.
9.
My Lord, seeking a short accommodation because the NHOs need to be tied. So,
yes.
Because of the long weekend, we have to receive the NHOs. Just seeking a short accommodation, just a week would be enough.
Okay. As prayed by MSSI, 1 week's further time allowed for affidavit. Yes. Yes.
10.
Lordship,
In this matter, I've already filed my affidavit, Lordship, on behalf of respondent number 3, the bank.
One is already filed from 14.
Yes, Mr. Person.
Your Lordship, if kindly pursue the affidavit filed by respondent number 3, Your Lordship.
What did it say?
At para 11, they have stated that under the instructions of the Director General of Police, Your Lordship, letter dated 5 of June 2025, Your Lordship, they have all been directed to unfreeze my account, Your Lordship. Now more than 2 months have lapsed and my account has not been...
That's true, Lordship. Lordship, what has happened, Lordship, is each bank branch functions as a separate entity, Lordship, because they have...
So, then how come you deposit money in Timbuktu in a fixed account here?
Lordship, if I may, Lordship, then what happens, Lordship, is that at the time of freezing, Lordship, the particular bank branch in Ahmedabad, they have used their bank code, IFSC code, Lordship. So the bank, State Bank...
It's a uniform system, you know, that's all, it's what they call it, there's a word for it, unified.
Lordship.
Yes. Then,
Lordship, what has happened?
When it comes to these things, the banks have become independent. When it comes to accessing a petitioner's account, whether he's cutting the TDS, I mean, it's unified.
Lordship, what has happened, Lordship, here is that to unfreeze the account, Lordship, the IFSC code of Ahmedabad is required, Lordship. It has to be done from that end only, Lordship. Lordship, that's why this any order, Lordship, will maybe kindly be directed towards Ahmedabad branch, Lordship. Because from here also they have written, Lordship. On the next occasion, Lordship, I will. Lordship, yeah. Lordship, because in the petition, Lordship, only the SBI Madan branch has been made a party, Lordship. Gujarat branch has not been made a party, Lordship. That's the difficulty.
How what these people do?
They are also not coming for us. Respondent number 2.
The affidavit number 3 is saying which paragraph?
Para 11, Your Lordship.
Para 11 of my affidavit, Lordship.
Is that so? Now you can't, SBI headquarters can't be, you are part of SBI, the same bank.
Lordship. Lordship, only the difficulty, Lordship, is only the branch manager SBI Madan has been made a party, Lordship.
So?
Lordship, now from...
you can't bank to bank, you don't communicate.
They have communicated,
They have unified account. I can deposit money in NPS in India, reflect account, right? You have one account number. You don't for SBI, you don't even have to have multiple accounts. One account you open, it operates wherever you go, right?
Absolutely, Lordship.
Then?
Lordship, I get that, Lordship. That's why I have annexed this. We have annexed this annexure, Lordship. Because from our end also there is a difficulty because we have communicated multiple times to Ahmedabad, but they have not acted on it, Lordship.
See, this is from Gujarat only.
Gujarat.
Then
Gujarat
you won't bank. This is a letter from the Central Police State. They're not accepting this also.
They have received it, Lordship, but they have acted. They are yet to act on it. Lordship.
Why?
Lordship, for reasons unknown to us, Lordship.
We're not going to issue orders to them. This order of Gujarat itself, you better take steps at your own level.
Lordship, we'll file. We'll make the first steps, Lordship.
No, it's an affidavit has been filed by respondent number 3. That is the SBI Madan branch, wherein is indicated at para 11 that that directions have been issued to the local head office State Bank in Ahmedabad for defreezing the accounts of the petitioner. Stop. However, it appears, as per the submissions of the General Counsel petitioner, the same is yet to be acted upon. So, next, Ms. S. Pandey, General Counsel number 3, submits that orders may be issued to direct the said branch, local branch, State Bank India, Ahmedabad, to comply with the direction issued for unfreezing. Stop. This court, on hearing the parties and also on perusing the letter dated 5/6/2025 issued by Superintendent of Police, State Cyber Crime Cell, Gandhinagar, Gujarat State, finds it difficult to accept as to why the account is yet to be unfrozen. Stop. The letter, it is seen, has been issued from the state of Gujarat itself by a competent authority, and there is no reason there's no reason. Has been only addressed to the nodal officers there in India, and there's no reason that the said direction be not complied with. It will be observed herein that in matters of transaction, it is always submitted that the accounts or the entire banking system is unified and uniform. It is expected that the respondent number 3 take immediate steps, feeling which further orders will follow, which may even involve payment of costs. Yes. Copy of the order be made over to the petitioner respondent number 3. And I can't understand
11.
all these matters. When it comes to consumers, customers, treating them like they're dirt. Yes.
Your Lordship will be filing in the course of the day, Your Lordship.
What will be filing?
Affidavit rejoinder, Lordship.
Rejoinder.
In the course of
to file a rejoinder.
We'll close it the next day.
Close.
Yes.
After a week, Your Lordship.
Highly
Yes,
obliged.
MS. Sorry.
Al Panjam, Your Lordship.
Yes, Panjam submits the after we jointly file the course of the day and lists the matter after 1 week for further orders.
Highly obliged.
Obliged, Your Lordship.
Item number 12.
Well, this is a matter pertaining to VEC, my lord, Village Employment Council. Now, my lord, the state during the pendency of the matter has conducted a re-verification, my lord, and they submitted in their affidavit. Now, my lord, what I've gone through that, my lord, government servants, my lord, working in forest department, they are in the beneficiary list, my lord, and so much so that one advocate practicing in High Court is also a beneficiary, my lord.
He's a job card holder.
He is a job card holder, my lord.
That's very good. Who's the advocate? What's the name?
I'll point it out.
What's his name?
Where is it? Where you have stated then?
I hope it's not Mr. S.K. Hassan or Mr. S.A. Sheikh.
My lord, in my rejoinder I filed today, my lord.
Yes.
Your Honor, if Your Honor
Can I just
1 second.
My lord, page 6, my lord, of my rejoinder today.
Where is the name of the lawyer?
Insofar as LS job card bearing number so and so, in bracket we've given the name, my lord. The verification report so and so confirms that he is a practicing advocate in the High Court of Meghalaya. However, despite his absence during the his name has been treated to be genuine without any proper verification.
Who is this R.H. Alice? You are the person. How come he's job card holder?
No, Your Lordship, I have already informed to the previous secretary to delete my name.
Why you were job card holder earlier?
Before I was student, that time I have enrolled. After that I have...
You went and did 100 days work?
Yes. Yes, Your Lordship.
You were paid for that?
Yes.
12 accounts to substantiate that you were paid?
It was cash payment. So I have received. My father was, at that time, he was alive.
You were secretary to VC?
No. I many times, even I have given written to the previous secretary also. And during verification process also I have told that my name should be deleted from the list.
Then Mr. Shulai, what kind of verification is this? Even the advocate also said his name
and government servants.
Your Lordship, my wife is there. She have enrolled in that one.
No, the wife is a different story. But if he has said that he's a practicing lawyer, if he said himself he's asked for deletion, it's a very serious matter.
My lord, kindly see page 57 of the of our writ petition, my lord. My lord, I'm not on any particular person, my lord.
No, not person. I mean, what I'm saying is very fair also.
My whole submission
is the whole verification is just a farce.
And even government servants are there, my lord. So, my lord, what I'm praying at this stage, my lord, I'm not sure. If Lordship permits me to file a specific representation to the BDO, my lord, let BDO dispose of that
Lordship, can we have P65 of our report, Your Lordship? Not there anymore.
It's not there, sir. His name is not there.
65?
Lord, 65.
His name is there, very much.
Of our affidavit, Your Lordship.
The list?
Lordship, yes, the list.
Yes.
Lordship, kindly see. Serial 45, Your Lordship.
Yes.
Lordship, kindly see 19817. It's no. It's not.
Why are you reading? Where are you reading?
Lordship, kindly come to page 65.
I have 65.
Lordship, yes. Of the report, Your Lordship. We filed the report, Your Lordship.
This is what is supposed to report? This is pagination goes to 65.
65.
Panchayat Sobri Bari 60.
This is the affidavit filed on 26 or 23. Huh?
1st of August.
Yes. Lordship, yes.
Yeah, then
31st July. Lordship, can you have page 65? Lordship, kindly have serial number 45.
Goldanar Begum.
Lordship, yes.
Then
kindly see the job card number, your Lordship. Rahabul Hok Alice 199817. At page 6 of their reply, your Lordship. At 12.
Probably yes.
Lordship, yeah. And then your Lordship will see at page 65, your Lordship. This is the final list, your Lordship. His number is no more there in the final list.
Knows no more there.
My lord, kindly come to page 80, my lord. His name is there, my lord. Page 80 is the final list, my lord. Page 80, the first item, my lord, Rahabul Haq. His name is there at serial number 143, my lord. Page 80, my lord.
Yes.
The first, the very first name, my lord.
1917. This is your name. It's Alice. See?
This has been deleted, your Lord.
No, this is the final list in your affidavit.
Nowhere deleted. Deleted is marked in one column. This one, like for these reasons, Sohida Khatun deleted with effect also expired.
And I can point out there are several discrepancies. One person working as forest guard, my lord, his name is there in the job card.
Those people are notorious.
My lord, what I am praying, my lord, if Lordship permits me to file a specific representation to BDO, my lord. Let BDO take up the case one by one, my lord, and dispose it of.
This is a rejoinder. Rejoinder has been filed by the.
Will verify it, your Lordship.
By the writ petitioner, wherein it has been stated that even a practicing advocate of this court
and government advocates and some government
other government officers have been listed as verified voters or job card holders. The advocate concerned is one Shri Arij Alice, who is present in court today and who has submitted that though he has represented for his deletion, unknown to him, his name has still appeared in the list.
I may be allowed to give some submission, the Lordship.
Yes.
Lordship, the previous his previous secretary, he has made master roll in my name. I don't know how he has done. He has credited some amount in my account also. I have told them, but still.
You file a formal complaint.
Yes, sir.
Yeah, too much of politics in this business.
Hand and glove is all this thing. Yes, sir. No? This is his name still has appeared in the verification stuff. Mr. Arij Alice, CHF, who is present in court today, has also apprised the court that is not only in this case, as the secretary has even entered his name as a master roll.
Yes, sir.
With the PUD or as a master roll, and certain amounts are also credited.
And someone has given proxy in my name.
Yes,
Caused my signature also.
Which he submits has been by falsification and impersonation stuff. Next paragraph. This court takes serious notice of this aspect and directs the state respondents to obtain immediate instructions from the officer concerned, that is the BDO of Salsala, Sinati block, West Garo Hills, failing which further orders will follow. Just the matter after 1 week, 2 weeks.
Then I will re-verify the list also, your Lordship.
we'll have to do something here. This whole business verification is has become you're already subverting and corrupting the entire scheme.
Meant for poor people.
Because yes,
Meant for poor people, my lord.
there's a lot of defalcation. That means the money for development for a community and what is being done, they don't even care. They put the name of a lawyer also just to fill the names on the list.
13.
Voting representation will be your own help.
13, 14, Lord. 12, 13, 14.
Yes, list together after 2 weeks. Yes.
Hearing 15.
My lord, 13, my lord. We have come against page 30, my lord. This program implementation committee constituted by the state, my lord. Kindly see page 30, my lord.
Of which matter?
Next, 13.
Yes.
Number, this is a program implementation committee constituted on 21st March 25 with these 5 members, my lord.
Yes.
Now, number 2, my lord, Swapna Das.
Page 30.
Page 30, yes.
Yes.
Now the rules require, my lord, it has to have minimum 5 members, my lord. So 5-member committee was constituted. Now the number 2, Swapna Das, my lord, her name has been removed from the beneficiary list, and she still is there in the committee, my lord.
Where is she? She has not filed application.
As per the verification report in the other case,
Her name has been deleted from the voter list, this beneficiary list now, my lord. But it still remains in the committee, my lord.
In WC 175 from the voters list,
my lord.
Job card list.
In the job card list, my lord.
This is WC 175. In this connected matter, it is reported by the Senior Council that.
But only thing, your lordship, is that these people have not been arrayed as a respondent here in your lordship.
We'll just flag the irregularities. That has been reported that one of the members of the program executive stroke implementation committee (PEIC), namely Srimati Swapna Das, appearing at number 2. His name has been removed from job card holder, though she remains in the
21 March 25
implementation committee. Mr. Andy Shulai learned AG to also obtain instructions on this aspect. Yes.
Number 2, my lord, let's see. She is an ASHA worker, my lord. An ASHA worker, how can she be job card holder also, my lord?
ASHA worker can keep it very minimal amount.
14. 14.
14 is the same one.
15.
Please. This was the election petition, lordship, where there was a issue regarding the true copies.
Where's the other side? Where is the matter?
Up till this time, my learned friend was seeking adjournments. I don't know whether he wants to take, he's interested in the matter to take it.
We had to complete some instructions because originally it was filed by a counsel from Delhi. That is why it was adjourned for a few days, lordship. The issue, lordship, what had fallen was essentially the issue of whether the true copies were supplied or not. Now my learned senior friend, he produced a copy which he says was made over to the respondent, which is absolutely unsigned. In fact, it is a blank copy, no dates, no signatures, and no notary, nothing. That was the copy which he produced in the court. But your lordship, my humble submission is that I don't know for what reason, but on a very specific instruction, my submission is that on the date of presentation of the election petition, lordship, true copies were made, duly notarized and signed by the petitioner. What was not done, fairly I am submitting, was that seal certified to be true copy, that was not put. And in their show cause, in their 711 application also, lordship, there are 25 paragraphs of pleadings. Nowhere have they stated that the copy that was received by them from the court
was entirely a blank copy. They say very specifically at page 28 that the date of signing was not mentioned.
Yes.
Lordship may kindly have the miscase number 28. Lordship has miscase number 28. Kindly see page 27, para 21. Lordships have it.
Para?
Lordship may kindly have page 19 first. Para 19, I'm sorry.
Application.
Paragraph 19 of miscase number 28. Page 26.
1 second. Yes. Page 26.
Yes, Lordship. Page 26. Para 19.
One thing before we commence, are you interested in pursuing this
Lordship
matter?
is. Because only the difficulty was
But you don't show that.
Lordship, the only issue was
the matter pending for.
We had argued it and then he came with that blank copy. That is why I had to take some specific instruction that was recorded also. I had verified with the. Kindly see, Lordship, page 26. Para 19.
Yes.
It is submitted that the present petition is liable to be dismissed inasmuch as the true copy of the petition attested by the petitioner and the signature of the petitioner was not served to the answering respondent. It is submitted that 81(3) of RPA provides that every copy of the petition must be signed by the election petitioner with the attestation that the same is a true copy of the election petition. It is submitted that this provision is not complied with by the petitioner and the same is a ground for rejection of the petition. Para 20. It is submitted that none of the pages of the copy of the petition served to the answering respondent is signed to true copy of the election petition, and accordingly it is submitted that the election petition is in violation of 81(3) of RPA. Now Lordship may also see the next page. This is page 28, continuation of para 21. From the beginning, Lordship. It is submitted that order 6 rule 15 provides that a person verifying the pleadings shall also furnish an affidavit in support of the pleadings. It is submitted that under order 6 rule 15(3) of the CPC, the petitioner is bound to mention the date of signing of the petition. However, the same is not mentioned in the copy of the election petition supplied to the answering respondent. There is also no signature of the advocate identifying the signature of the petitioner in the copy served to the answering respondents.
Yes.
So, Lordship, in my show cause also, I have fairly stated that, in fact, the seal or the attestation that certified to be true copy was not there, but all the pages, including the annexures, were duly signed in original by the election petitioner himself, Lordship. And they, Lordship,
so they filed this 711 application
on this ground
on 1 year ago.
1 year ago, and they also took
2 years ago. Sorry,
2 years ago.
That's August 23.
I think 2.5 years ago.
We are in today is 19th August 25.
I appreciate half
so
the time has
now
gone.
The thing is that you are making these objections now.
Lordship, because what had happened is I had filed my reply, they filed a rejoinder, and the matter was heard. Where I had submitted, Lordship, that by not giving the seal or the attestation, it would still amount to a substantive compliance of section 81 and 83 of the RPA. Thereafter, Lordship, what happened is that the respondent produced a copy attached with the notice issued by the registry saying that this is what has been served to me and this is entirely a blank petition without even a date mentioned, without anything. In that circumstance, Lordship, I had to take instruction, and my instruction is still the same, that what was served was a true copy, but the seal was not
produced on that day then?
It is, Lordship, what has probably happened is that at the time of motion of the time when the matter was moved, Lordship, the respondent had entered appearance, steps were taken through the registry, but in the meantime, as reflected in the order also, they had prayed for a copy to be served in the course of the day. Perhaps, Lordship, perhaps that was the copy that was served in the course of the day
not the one who served to them through the
Lordship. Court. That was a true copy.
Through the court, another copy was served.
That was the original copy, duly notarized, duly signed. Only it was not sealed.
How are we to ascertain that?
Because that is the instruction, Lordship, which I have, and that is because that is why I have made my reply also in that line, and that was never their plea that they have got an entirely
Mr. blank. Pandey, when are coming?
Blank copy.
Mr. Pandey. You've heard that they said that the copy that you produced for the court to substantiate your case that there is unsigned, that is a copy that is given casually, and the original served copy contains all the requirements
except the attestation.
I have till today I have not yet chanced upon any ink which can erase the signatures of the election petitioner from the petition. I have supplied the copy that has been given to me, and that is part of the record of your lordship's file.
Yes.
So I have been served upon a copy which.
This is the one. That's the one that they produced.
That is the one they have produced.
Out here, nothing is there.
Lordship, yes. And in fact,
and then where the copy do you serve on them?
Lordship, that I have served through post. I even have the.
So you mean they're concealing it?
It appears so, Lordship. It appears so, because even the registry would not have accepted that blank petition also, Lordship, without any date, without any. And had that been the case, they would have not said all of this in their application. They would have simply said.
This bears the seal of joint registrar listing.
The first page, Lordship. In my respectful submission, Lordship.
No, we're going somewhere else, Mr. Deb.
I appreciate it, but that, Lordship, if it was a situation where this was the case, they would not have stated so in
Very
the application.
serious allegations, the Pandey.
In the application, they say it is not signed to be a true copy.
It amount to tampering with records.
Then they would have said, Lordship, that what I have received is a completely blank copy without even a date.
Admittedly, my learned friend was not the counsel who was engaged by the election petitioner. He has no knowledge about how the petition was served, and merely based upon certain instructions that he has received from the erstwhile counsel.
We can't proceed in this manner.
Yes.
Because my only humble submission is, Lordship, had it been a case.
There's nothing, it's only on the hearsay. It comes hearsay.
Lordship,
it becomes secondary. The thing is that if they produce a copy, and you say this isn't the copy.
Lordship. Because in my humble understanding, even logically, Lordship, if that was the case.
This election, it's not live stream, right? Election matters. So there's no YouTube account or to show whether that
was recorded in the order that coffee to be served in the course of the day. After
you come up with the particulars. When was the order?
I'll do that. I'll do that, Lordship. Because what had happened, first they went and applied for a certified copy from the registry. Then a copy was served through the registry upon issuance of notice, and yet a third copy was served in the bar, Lordship. Those are recorded. It's not that I am. And had it been a case where it was a blank copy, they would have mentioned in their application that I have received a completely blank copy.
We will examine the application.
Lordship.
Yes, it appears that this is on hearing the matter. It appears there are serious issues have been raised by the counsel for the election petitioner with regard to the exact copy that was served upon the respondent stuff. As Pandey Leonard counsel for the respondent raise a matter be listed on when 25th to enable him to
25th?
Yes, 25th. It was Monday. Yes, 25th.
I'll
get the appear physically, yes.
16.
I can't not
because that was a very specific. In fact, what was produced even struck my eye.
Beyond the scope adjudication.
I appreciate it, Lordship, because what he had produced, it was even glaring to me that how come this can be done. So I have taken very specific instruction, clarified from the registry also. That was what, Lordship. I'm blessed.
You verified the attendance sheet?
Yes, my lord. I'll just point out. In fact, my lord, 2 writ petitioners. There are 22 writ petitioners. Out of these, only 2 and 3 applied under, my lord, Right to Information Act, particularly for the year 23 only. Now, lordship will kindly come, my lord. This affidavit, their affidavit. Lordship will kindly, my lord, that affidavit containing the annexes. My lord will come to page 44. Page 44, your lordship.
Affidavit.
My lord, that additional affidavit they file, my lord, including the attendance register.
Yes.
Lordship, 44 to 67, that is pertaining to the period January 23 to December 23.
Till number 8, page 44.
8, my lord. This is, my lord, the writ petitioner number 3. Now, my lord, you will see, my lord, he has never signed. Never signed, Lordship. I have gone through.
Never signed?
Never signed for Saturday and Sunday. No, these only make my case, your lordship. Saturday and
Sunday. What about this other one then?
Yes, my lord, I am just coming, your lordship. So, my lord, he has never signed. Now, my lord, coming to, my lord, the respondent number 2, page 2243, your lordship. That is also for the period 23. That is after we file the writ petition. Now, my lord, we do not know, my lord, this is a matter of facts to be ascertained, my lord, how it has entered. We have cross-checked, my lord, from the records. He is not a, my lord, worker entrusted with essential maintenance. He is not supposed to be there. Now, how this has entered, my lord, these are matter of evidence. So, my humble submission, your lordships, now he is relying on 2 attendance register of a particular period of 2 writ petitioners. Now, these cannot be a clinching evidence, my lord, for a direction in respect of, my lord, 22 writ petitioners to grant them relief, my lord, pertaining to the period 2011, my lord. This writ petition was filed only in 23 or 13 years after the, my lord, notification was issued in the year 2011. Now, my humble submission, my lord, delay and latches, lordships, and this is, my lord, there are admittedly now, my lord, disputed question of facts. Admittedly, my lord, disputed question of facts. Now, these cannot be ascertained by the writ code, my lords. And, my lord, delay and latches, my lord, only one judgment I am relying, my lord.
We'll have another day. Nothing too good, yes. Mr. SN has submitted that the attendance sheet as produced has given rise to disputed facts.
Next.
So, this is a matter for further consideration on.
I'll take instruction also.
Yes, for concerns also, or to also enable Mr. Chariso to obtain instructions. Yes. Yes, after 1 week.
You could serve the copy.
18.
Served.
18.
My lord, there is also Nehu, my lord. This is, my lord, regarding regularization in group depots. No, that's stand abolished. Now, my lord, how it is for the UGC, my lord, they have to show a way, my lord, how it is to be done. On last occasion, the copy was not served. Now I have served a copy.
Where is UGC?
This is Sonia.
Mr. Pandey?
No, no.
No.
This one?
New council is there.
Name?
After 1 week, yes.
Yes, lunch day.
And none appears UGC. That's after 1 week.
Next.
30.
My lord, this is a case, your lordship. My lord, I am going to repeat. My lord, this is a case, my lord, I need to place, my lord. It's short facts, because earlier occasion, a lot of confusion has arisen, my lord, because I have not, my lord, elaborated the facts. I'll just elaborate the facts. I don't know, your lordship will take it up today.
We'll take after 1 week, Mr.
Lordship. All the facts, my lord. In fact, there is certain confusion, my lord. I'll try to settle, my lord.
Yes, on the prayers also, this after 1 week.
After a week, your lordship.
After 1 week.
Oblige.
34.
May I be lordship?
Yes.
My lord, this is a limited prayer in this case, my lord. Only conditional benefit has not been revised, my lord.
We'll after 1 week, Mr. Kumar. Yes, this matter.
My lord.
Yes.
My lord. That's all.
Where Dr. Muzika and legs?
Watch.
Thank you, lordship.